condemned the action of the Kerala High Court to annul a marriage under a habeas corpus petition. Your Lordships, the Honorable Apex Court had held that the jurisdiction of the court had ended as soon as the appellant's wife appeared before the court and affirmed that there was no illegal or unlawful detention perpetrated by the petitioner appellant, and further held that interference with the marriage under 226 was not proper. Therefore, even in the present case, the injustice is patent. Hence, the present matter is a quintessential, exceptional and special case as per the requirements of Article 136, hence is maintainable and deserves to be allowed. With that, Your Lordships, I shall proceed to my second issue, which is whether the impugned order is per incurium. Your Lordships, the order is not valid on the basis of 4 points. Firstly, Your Lordships, the order, as I already have pointed out, is per incurium the binding precedents of Shafeen Jahan case, thus is violative of well-settled principles of judicial discipline and propriety. Secondly, Your Lordships, the High Court has exceeded its mandate conferred under habeas corpus petition, which is in ignorantium of the nature, scope and intendment of such proceedings. Lastly, Your Lordships, there has been a serious invasion of Articles 19, 21 and 25. Now, Your Lordships, I shall quickly point out the facts of the present case, which bear a striking resemblance to Shafeen Jahan case as per the pertaining to the CIA's report. Now, Your Lordships, even in that case, there was an NIA's report to which the court had held in para 55 of the case that investigation by the NIA with respect to any matter of criminality may continue in accordance with law, but the investigation shouldn't encroach upon the marital status of the parties. Thus, this clearly shows that the CIA's report cannot have any bearing on the marital status. Further, Your Lordships, I also want to point out that on the timeline in the present case is very suspicious in itself. Lordships may kindly notice that she went missing on 6th of March of 2021. The parents waited 6 days to file a missing persons report on 12th of March. And after that, the parents for 9 months did not showcase any concern for their daughter's whereabouts, because the parents approached the Honorable Allahabad High Court only after 9 months on 28th November. The parents for 9 months, they did not take any measures to locate the daughter. Further, Your Lordships, on 28th November, the respondent approached the Honorable High Court by way of a habeas corpus petition. The High Court passed interim orders to keep surveillance on Safina. It is submitted that the court ordered surveillance on Safina before her first appearance, which is also an invasion of right to privacy. Further, she appeared before the court on 10th and voiced 10th December and voiced her, Your Lordships, 1 minute extension to just sum up my arguments. And if Your Lordships may provide.
We are not in a position to give extension to everyone, but please just finish.
30 seconds, Your Lordships. 30 Very well. Okay. Lordships, despite this affirmation by her, the court directly annulled the marriage against the wishes of both parties merely on the basis of suspicious grounds, which is vague, excessive, and manifestly arbitrary beyond the scope of a habeas corpus petition. As held by the court in a catenary of judgments, that suspicion, however grave, cannot take the place of proof. In fact, after annulling the marriage, the court ordered a probe into the petitioner. Into his alleged involvement with the IFO, which further implies that at the time of the impugned order's passing, it was done on the mere suspicion. Moreover, the petitioner's guilt can be determined only after he is booked under an act and prosecution is done under a fair trial. Thus, the Honorable High Court...
Thank you, Counsel, but I think you are still confusing between a finding of guilty and directing an investigation to take place. Suspicion, of course, a strong suspicion is a ground for investigation.
Very well. I agree.
Thank you very much. Your time is up, Counsel. Thank you.
Okay, very well. Obliged, Your Lordships.
Am I audible, my Lordships? Very well. May it please this court. Permission to address this honorable bench is your lordships. Very well, your lordships. I am speaker 2 for the petitioners and I shall be addressing this honorable court on issue 3. Very well, your lordship. Permission.
Remind us what issue 3 is again.
Very well, your lordship. Issue 3 deals with the legality of Safina's conversion, my lordships. Very well, your lordships. Permission to commence with the arguments. Very well. It is submitted that the conversion of the appellant's wife is lawful as her bona fide change of heart towards Islam is well within the constitutional limits set under Article 25, Clause 1, Article 19, Clause 1, Subclause A, and Article 19 of the Constitution of India. It is submitted that in this factual conspectus, the decision to convert was free from any kind of coercion and was simply a bona fide conversion to Islam. It is further submitted that once the appellant's wife commenced her college at the International Institute of Fashion Design in Allahabad, she became good friends with Tuba and Tansila. It is further submitted that she herself was infatuated by their community's ideas and principles, especially Islamic fashion. Her passion for fashion started drawing inspiration from Islamic ideas. Subsequently, she started residing with her friends. Subsequently, she started residing with her friends. It was held in Rev Stanislaus versus State of Madhya Pradesh, as it is mentioned in the para 23 of page 7 of the compendium, that these overt facts and expressions of one communities are protected under Article 25 as propagation, which further protects the rights to communicate beliefs to another person or to expand the tenets of one's religion. My lords, it is further submitted that Safina's father is a firm follower of Hinduism, who had forbidden her from putting up with Tuba and Tansila when she expressed her growing interest towards Islam. Thus, the father, being a devout follower of Hinduism, as expected, would be against the impugned conversion, no matter what his daughter desired. But there's no cavil that the court cannot disregard her choices in the same way. My lords, it is further also opposite to mention that even though on 28 November 2020, Safina's father had filed a petition in the High Court alleging that the appellant's wife was forced conversion, the High Court didn't pass any adverse orders and passed interim orders to keep surveillance on her, which is indicative of the fact that the possibility of a forced conversion didn't seem plausible to the High Court itself at that time. Thus, even the High Court wider order dated 20...
Counsel, I think I will need a little more clarification here. You and your co-counsel both seem to be attacking sharply the interim orders that the High Court has passed of surveillance, etc. Are you SLP? Are you in SLP against those interim orders?
Very well, your lordships. Yes.
Have you challenged those interim orders in the current SLP council? Please be very sure about that.
No, my lordships, we are not challenging the
Yes, then you will have to refrain from making any submissions against orders which are not impugned in the current SLP.
Very well, your lordships. I bow down to your lordships. Very well. Even if in arguendo the CIA's report is considered, the petitioner cannot be involved in her conversion because he wasn't in Safina's life when this infatuation towards Islam had started. It is also opposite to mention that the appellant's wife had developed Islam way before she met the appellant. In fact, she even disobeyed her father.
Counsel, if you can assist me again, please. What is High Court's specific finding on the conversion of the lady?
Very well, your lordships. Can you please repeat the question?
My question is, what has High Court specifically found on the conversion of the lady? Have they interfered with the conversion?
No, my lordship.
Then what is challenging?
At the time of the passing of the judgment, nothing had been said. We are contending the conversion here, my lordships. The petitioner does not have any,
You have a problem with the lady having converted to Islam?
No, my lordships.
You are here contending what? Has High Court annulled that conversion?
My lords, we are contending that even though that the petitioner's involvement is there in was found out in a CIA's report that he's a part of an IFO operative that is known to perpetrate love jihad, but we are not stating their involvement altogether. We are saying that she had converted way before she met Maqbool Khan. So even
are you challenging this finding of the High Court by which further investigation has been ordered by your client?
Very well, Your Lordships. No, we're not challenging that.
So please help me understand. I'm not really sure what you are challenging before us on the point of conversion.
Very well, Your Lordships. We are just trying to show that the petitioner has no involvement in Safina's conversion, my lords.
You need not, counsel. This is not a forum of expression of interest. This is a forum to challenge a finding of the High Court. If you can't show us that there is a specific finding of the High Court against you, then we will not hear arguments on this aspect.
Very well, Your Lordships. So,
unless you can tell us what you are specifically aggrieved by.
Very well, Your Lordship. The main thing we're challenging are the suspicious grounds under which the marriage was annulled. The suspicious grounds that were used to further declare the conversion as unlawful, my lords.
No, you just said that conversion has not been interfered by the High Court. High Court has annulled the marriage, not the conversion.
Very well, Your Lordships. Very well, Your Lordships. I bow down to Your Lordships. Can I please continue with the argument?
Yes, please do. So you are basically not, there's nothing against conversion. Your argument is also against the annulment of marriage. And you're trying to say that her marriage is proper and it cannot be found fault with just because she had converted.
Very well, Your Lordships. Firstly, we're trying to.
No, I'm trying to understand. Don't say very well. I'm just trying to understand what your contention is. Please don't allow me to put words in your mouth.
No, my lordships, we are just trying to show that her conversion was lawful in order for her marriage to be not annulled by the High Court at that time via the order dated 1st January 2021.
Please proceed as you deem appropriate, counsel.
Very well, Your Lordships. Even if an argument to the CIA's report is considered, the petitioner cannot be involved in a conversion as he wasn't in Safina's life. The petitioner has stated that he met Safina on an online matrimonial website which stated her religion as Muslim. The statement has been authenticated by Safina, who further on went on to repeat her desire continuously to accept Islam. My lordships, it is submitted that in argument...
Counsel, I have a question which may help settlement of this whole thing. Would your client be amenable to, if he really wants to marry the lady, would he be amenable to marrying her under the Special Marriage Act, where everyone can keep their religion in the manner they like?
Yes, my lordships, yes, very well. Under the Section 5 of the Special Marriage Act, they have provisions for their marriage too.
I know they have, but would your client be, because then he would be giving up the prerogatives that he has under his personal laws.
Yes, my lordships, yes. Yes, he would.
All right, please proceed.
I want to ask one question. Can you please explain on what ground the marriage has been annulled?
Very well, Your Lordships. The High Court had ordered and said that their marriage is annulled under suspicious grounds, my lord.
What suspicious grounds?
Very well, Your Lordship. The suspicious grounds that had been surrounded, that were the timeline when she went missing on 6th March, and then 9 months after she had returned, then the High Court observed that this is ground for suspicious grounds, and they annulled their marriage on aforesaid arguments, my lords. Very well, Your Lordships. It is tried that in order for a conversion
proceed.
Very well, Your Lordships. It is tried that in order for a conversion to be lawful, it must be honest and must be done without any intent to commit fraud upon the law. It is submitted that Safina had no ulterior motive behind it and gained no such advantage via the conversion, which is indicative of her fact of her bona fide, which is a key determinant of the legality of the conversion. If Your Lordships is satisfied with the contentions put forth, the council seeks permission to state the prayer.
Counsel, we are not obliged to tell you whether we are satisfied at this point or not. It is up to us. We will hear both the sides and we will decide. Please don't urge to know our satisfaction at this stage.
Very well, Your Lordships. Can I state the prayer? Very well, Your Lordships. Wherefore, in the light of the issues raised, arguments advanced, and authorities cited, the counsels for the petitioner humbly pray that this honorable court may be pleased to, firstly, grant special leave to appeal against the Honorable High Court order dated 1st January 2020. Secondly, set aside the Honorable High Court's judgment dated 1st January 2021, as it is directly in the teeth of Shafeen Jahan case, and the court exceeded its jurisdiction, which resulted in gross injustice to the petitioner. Thirdly, pass it.
I think you can leave it. We have your compendiums and the prayers, and the court is very wants to put on record the very able assistance rendered by you and your co-counsel. Thank you, counsels.
Thank you so much. It was a pleasure arguing before this bench.
Counsel seeks permission to approach the bench.
Okay,
Much
proceed.
obliged, Your Lordship. Counsel seeks permission to collectively address the bench as Your Lordship. Much obliged.
Please proceed, counsel. If we have something to ask, we'll ask. Please proceed.
Indeed, my Lordship. Good evening, my Lordship. I am Sylvinn, and I'm here with my co-counsel Vineeth Prasad, and today we will be representing the respondents in the case of Makbul Khan versus the state of Uttar Pradesh and another. My Lordship, through the course of this case.
One second, counsel. I want to be clear on this. When you say you represent the respondent, how are you related to the lady?
We are not related to the lady, my Lordship.
Who are you then?
We are representing the state.
Okay, counsel, please proceed.
Much obliged. My Lordship, through the course of this case, we would like to prove without reasonable doubt that this petition for special leave holds no merit, and that both the conversion and the on the marriage of Miss Safina or Priya is invalid. My Lordship, the actions of the petitioners in this case is a classic case of creating a smokescreen of doubt and mistrust against the beloved judiciary by tarnishing their name through a farrago of misunderstandings and misrepresentations engineered in a way to make it seem like justice served in real was justice denied. To do this, I would like to address the first issue, which a very eligible co-counsel will be dealing with issue 2 and issue 3. The first issue being whether this SLP is maintainable before this honorable court. My Lordship, a special leave petition is not a matter of right, but it is a matter of privilege that is provided to the people by the Indian Constitution, which is to be granted only in exceptional cases where there has been a gross injustice of law, where there has been gross injustice has been observed, or there has been a substantial question of law. My Lordship, in this case,
counsel, before you proceed on the maintainability of SLP, we would like to understand what is the interest of the state in interfering in a issue which is covered by personal laws of the petitioners of the parties.
My Lordship, the state.
It's not a law and order issue. This is a matter of matrimonial relationship, whether it's there or not there. What is state's interest here?
Indeed, Your Lordship. So, my Lordship, the crux of this case is not only the matrimonial relationship between Mr. Makbul Khan and Mrs. Safina, but it is the fundamental rights and liberties of a citizen of India that is being questioned, my Lordship, in this case. The case before the High Court of Allahabad was a writ of habeas corpus petition where the High Court had the duty to ensure that the liberty of Ms. Safina was safe. And in the process of doing so, they were exercising their wide jurisdiction in certain matters to protect the liberty of Safina, which they felt was at threat at the moment, with a reasonable doubt to believe so, my Lordship, and they had substantial facts proving that their judgment was indeed right.
So that still didn't answer what is the interest of the state in interfering in the marriage.
My Lordship, they were protecting the fundamental rights of a person, my Lordship, the liberty of the individual, my Lordship.
Well, we are not asking you why the High Court has passed this order. We are asking you, why are you here defending the order?
My Lordship, I fail to understand how to answer that question, my Lordship.
All right, please proceed.
Counsel pleads ignorance. My Lordship, to prove that there is no substantial question of law involved, I would like to draw the court's attention to the case of Sanvat Singh versus State of Rajasthan, where the court had opined that Article 136 vests discretionary power which can be exhaustively defined but does not permit interference unless substantial grave injustice has been done and the conscience of the court is shocked. Furthermore, in the case of Pritam Singh versus the state, it was held that it seems clear that a wide discretionary power with which the court is invested under is to be exercised sparingly. And
you wish to say, counsel, you wish to say that there are two parties to a marriage. Both the parties come before the High Court. They say that they have married each other with their consent. There is no force or coercion on them. This is done out of their complete free will. The High Court still goes on to interfere and annul that marriage, which both the parties present before the court claim that it is a perfectly valid marriage, and they've done it. So I don't understand, how are you even contending that there is no substantial question of law requiring us to look at it?
My Lordship, through the course of
this case, shocks the conscience of the court. It is contrary to which law of the land?
My Lordship, through the course of this case, we would like to prove to you beyond doubt that the reason why the High Court in the first place intervened in the marriage of Ms. Safina and Mr. Maqbool in this case was because they believed that the liberty, a fundamental liberty and the free will of Ms. Safina was
and who
interfered
would
with.
judge that liberty and free will, counsel?
My lordship,
Who would be the judge? She is not a minor. She's not a person of unsound mind. She's not somebody who's suffering from any disability in law to make up her own mind.
My lordship, I completely agree that she is not someone of an unsound mind or a minor. She is indeed a major, but the organization that her husband is involved with is specialized in psychologically manipulating.
Counsel, let's not confuse issues here. There is full liberty left to the state. This is your own inefficiency and ineptness. If you have not investigated on those issues, the liberty has been left to the High Court, but even by the High Court, but even without the High Court leaving a liberty to the state to investigate these issues, I mean, you are free to investigate, but that you mean to say that a hardened criminal who is somebody who would be an anti-national or a complete terrorist, hardened criminal terrorist, he's not entitled to marry somebody of his own choice?
My lordship, he is definitely entitled to marry somebody of his own choice. But when he is accused for a particular crime, and that's his marriage is the crux of that particular crime, my lordship, that arises questions before a High Court, which is what
and where is that finding of guilt that that person is accused of the crime of marriage?
My lordship, he's an
that
active
investigation is still open qua you state.
No, my lordship, that investigation was indeed concluded by the Central Investigation Agency, where they stated that the organization for which Mr. Maqbool was a part of was indeed indeed converting Indians into Islam, Hindu Indians into Islam by systematic psychological manipulation, my lordship. And the fact that Miss Safina was missing for a span of 10 months, and coupled with the fact that she left everything, including her family, her religion, and her career and her college, and after that shows up in court one day under the influence of this manipulation.
Have you heard of Jain Munis, or have you heard of other people in different religions who have renounced the world, gone their own way? Indian Constitution permits them the complete liberty and latitude to do whatever they please to do with their life.
Indeed,
it's not for the state to second guess how citizens should be living their life.
I completely agree with your lordship, but the fact is there have been multiple issues coupled with over here, which is causing the state to have reasonable suspicion to believe that this is not just a case of her choosing to renounce her religion and move away from her faith.
Thankfully, counsel, our constitution does not permit the state to interfere in matrimonial relationships on the basis of reasonable apprehension. But I think your time is up. Thank you for your assistance.
Much obliged, your lordship.
Permission to approach the bench, my lords. My lords, I'm co-counsel 2, and I will be dealing with issue 2 and issue 3 of this particular case. My lords, issue 2 is whether the annulment order passed by the Allahabad High Court is a valid order. My lord, I would like to contend that it is well within the jurisdiction of a habeas corpus petition through the wide powers granted to the High Court through Article 226 of the Constitution to in fact look into the validity of a marriage in case. For example, I would like to draw the attention of the bench to the case of powers, privileges, and immunities of state legislature, in which the Honorable Supreme Court has stated that in case of a superior court of record, it is for the courts themselves to consider what falls within their jurisdiction. And again, in the case of T.K. Rangarajan versus Government of Tamil Nadu, it is stated that the High Court is empowered to exercise its extraordinary jurisdiction to meet an unprecedented extraordinary situation having no parallel. My lords, I would again like to focus on the facts of this case. My lords, the facts of this case show that she was missing for more than 10 months, and she was missing where even the police couldn't trace her, my lords. And after the period of 10 months ended, she has come out and stated that she is married to one Mr. Maqbool and is stated to have converted to the religion of Islam. My lords, I would like to again emphasize on the fact that Ms. Maqbool.
Who says she was missing?
My lords, the missing report was missing. A complaint was filed before the filed by the police, by the father, my lords, by the father.
Does the father have authority to file a missing report when the daughter is doing what she pleases, which may be against the wishes of the father?
My lords, but she was missing and the police could not even trace her, my lords. She
was brought before the High Court. Did she say she was missing?
No, my lords. So but then why was she not found by the police?
No, why is state trying to be protective about a woman here? This is a perfectly capable woman. She is major. She is recognized as an equal citizen under the Indian Constitution. There is no purpose for state to try to cajole and couch her in a protective manner by on that pretext trying to take away her rights and liberties. The courts of law under the Indian Constitution cannot permit this at all, Counsel.
But my lords, it is a stated fact that she was missing. She was not even found by the police. It is not that she was just away from her family. She was missing. It is not the fact that she was just living away from the family or the fact that she had cut ties with her family. It is the fact that she was missing.
The point is, was she missing? Did she say that she was missing?
My lords, no statement has been made according to those points, my lord.
The whole factual conspectus is extremely clear that she was doing what she pleases. Yes. She was living her life in the manner that she pleases. And that is something that is not palatable to the father. So the father, in the patriarchal mindset, he still thinks he owns the daughter, and the state thinks that they own the daughters of the country, and they want to interfere in her personal choices. The Constitution does not permit this, Counsel.
My lords, but the fact that she was missing plays a very important role, and the fact that she is associated to a person who is in fact alleged to have caused psychological manipulation is also a fact that needs to be considered, my lords, while answering this question.
So, Counsel, again, I'll put you the same question that I put to your co-counsel, that a hardened criminal, completely guilty terrorist, is he not entitled to a matrimonial relationship of his choice?
He is entitled to a matrimonial relationship if it is a legal matrimonial relationship, my lord.
How is this relationship illegal? Free will is not a condition in our country anymore?
No, my lords, but first of all, this is not even a legal conversion, my lords. And then they've stated this is a marriage that has taken place under Muslim law.
High Court has not interfered with the conversion as far as I understand.
But we would like to contend that as the issues raised by this honorable judge, by this honorable bench itself, is one of the issues that relates to the conversion, my lords.
Well, those issues are available and open for you to investigate. If it is found to be contrary to any law, then the action can be taken. Please don't deviate from the issue here. The issue here is about matrimonial relationship that the parties have arrived at out of their own free will.
My lords, but valid steps for that matrimonial relationship has not been fulfilled at all. One of the valid essentials for a Muslim marriage is that both of them be Muslim. Here there is no credible proof to show that she has in fact converted to Islam. There are certain valid steps to be followed for individual to convert to Islam, and those valid steps are not followed in this case, my lord.
Nobody challenged her conversion. There is no finding on the conversion.
My lords, but it is a question posed by this bench, my lords. And conversion is a valid part to the marriage.
So would the state allow if the parties were to marry under the Special Marriage Act?
My lords, yes.
You have a problem. Would you? I mean, the council, you will have to make up your mind on and make a submission that is not contrary to each other. If you will, do you have a problem with the petitioner because of his antecedents, or do you have a problem with the conversion of the girl?
My lords, we have a problem with the conversion of the girl, my lords.
Please proceed.
Okay, my lords. I would like to draw your attention to the valid steps that needs to be followed for a legal conversion of an individual to the faith of Islam. That is again stated in the Uttar Pradesh prohibition of religious conversion. That's according to section 12. There are certain valid steps that has to be followed. For example, a notice of 30 days must be given to the district magistrate, where in turn they conduct a police investigation, and after the approval of the said authority, only can you be considered a valid convertee. These steps have not been followed, my lords. And according to other well-established laws for
council under this law, yes, did you take action under this law?
No, my lords.
So how in a habeas corpus petition all these actions can be taken? The entire investigation has been left open to you. If you find anything that is contrary to existing laws, you take action.
My lords, while hearing this habeas corpus petition, we go into the validity of the marriage, no, my lords. And the validity of the marriage is governed by this ordinance.
Without any challenge to the marriage, without any challenge to the conversion. Council, please remind me, what is a writ of habeas corpus?
My lords, the writ of habeas corpus is to produce the body, my lords, and for the person being and the person who is detaining another to prove for the reason for that detention, my lords. And if it is not a legal detention, for them to.
And it ends there, counsel.
My lords, but through the wide powers granted to the High Court through 226, they can pass orders to satisfy principles of justice, my lord.
Even without any challenge being made to the marriage or to the conversion. Was this a petition under 482 of the of CRPC?
No, my lords.
So then inherent powers are not even called for.
My lords, but this is a important aspect of what is happening to Miss Safina here, my lords.
Please proceed, counsel.
My lords, yes, not
One
only the
question,
yes,
question
yes,
I
Your
want to
Lordship.
ask you. You have referred the ordinance, whether the ordinance is applicable in this case, whether the marriage or the conversion took place after coming into force of the ordinance or it took place before it.
My lords, if I could, you were not very clear, my lords, if you could just
Whether
repeat
the conversion of the lady to Islam or her marriage with this Mahmood took place before the ordinance came into force, or it took place after the ordinance.
My lords,
came
we
into
would
force?
like
How
to
the ordinance is?
Yes, my lords, I understand your question, my lords. Much obliged, my lords. My lords, we would like to contend that the declaration that Safina in fact converted to Islam is a credible declaration is only made when she comes to court and states it, my lords. That is on December 10th. That is after the ordinance is passed. The ordinance was passed on January 27th, my lords. There was no other credible declaration prior that states that she had in fact converted to Islam, my lords.
Okay, proceed.
My lords, I think the arguments are concluded. If I may move on to the prayers.
Please, please do.
Thank you, my lords. Wherefore, in the light of the facts used, issues raised, arguments advanced, and the authority cited, it is most humbly and respectfully prayed before this honorable court may be pleased to adjudge and declare the special leave petition may not be considered. The annulment order of the marriage between Safina and Maqbul passed by the Allahabad High Court to be held constitutionally valid, and the conversion of Miss Safina to the Islamic faith is invalid in the eyes of law. The court may also be pleased to pass any order with this honorable court may deem fit in the light of justice, equity, and good conscience. Thank you, my lords.
We place on record our gratitude for very able assistance by you and your counsel. Thank you very much.
Thank you. Thank you, my lordship.
Are there any rebuttals or is it done?
Your Lordships, may I be permitted to rebut?
Yes, please, if it's permissible, please proceed.
Court Master?
Yes.
Very well. So, Your Lordships posed a question to my counsel, to my learned friends regarding the UP ordinance. So, Your Lordships may kindly note that the UP ordinance was assented on 28th November, the very same day when the father of Safina approached the court under a habeas corpus petition, alleging that her conversion was forced, thereby implying that the conversion already took place, which further showcases that this ordinance does not apply to the present case because her conversion was took place prior to 28th November. Secondly, Your Lordships also posed a question to my learned co-counsel regarding the grounds on which the marriage was annulled. It is submitted that the grounds were not deemed suspicious grounds, and they are vague and against the principles of natural justice. Thus, we have approached the Honorable Court. Lastly, Your Lordships, the CIA has not booked the petitioner under any act. Thereby, he is still entitled to a fair trial where he shall be presumed to be innocent until proven guilty, and this has no bearing on the marital status of the petitioner and Safina. With that, I conclude my rebuttal time due to the paucity of time. It was an honor arguing before the bench.
Thank you, counsel.
Counsel seeks permission to approach the bench.
Please, counsel, proceed.
My lordship, as a first answer to the UP ordinance, hypothetically assuming, let's assume the UP ordinance is not applicable in this case. That does not change any fact that our submissions made that the conversion was invalid. It still holds ground, my lordship, because even if the conversion was not under the UP Ordnance Act and say it was under the Muslim law, which is the Sharia Act, it still states that for a valid conversion to be in place, there must be a publication made in the official Gazette of India, and the information must be passed to the magistrate. Neither of this has not been done, because if the information was passed to the magistrate for an investigation by the police into the order, the missing persons report would have come up there, and they would have indeed found her, my lordship. And secondly, I would like to rebut one of the statements made by the petitioners in their statement, which stated that the father had not taken any measures for 10 months before approaching the Honorable High Court, which is completely wrong, my lordship, because in the undisputed fact, it is stated that he approached the police, and as any reasonable man, a citizen of India would do, is first approach the police and try resolving the matter with the police, with their trust in the police. And by doing that, he filed a police complaint for a missing persons report, which is what his duty was, my lordship. And I would further like to hand it over to my co-counsel to take it over from here, my lords.
My lords, I have nothing to add. Thank you, my lords.
Thank you, counsels. Thank you very much.
Good evening, everybody. I am Deepak Thakur, co-founder Nyayshastram. After conducting 5 successful rounds, we have now reached to the valedictory ceremony. It's an honor and privilege for us to host galaxy of legal numeri for the valedictory and the judges who took part in the other rounds. I now invite Arif to formally introduce Aishwarya ma'am and invite her to say a few words.
Thank you, Deepak. Good evening, everyone. With utmost honor, I am happy to introduce our first guest of honor for the valedictory ceremony, Ms. Aishwarya Bhati, Additional Solicitor General, Supreme Court of India. Ma'am is the first woman from Rajasthan to have secured the position of a senior advocate. She has served as an advocate on record and the secretary to the Supreme Court Bar Association. She was even appointed as the Additional Advocate General for Uttar Pradesh in the year 2017. Her work has been inspiring to everyone, especially to us, the lawyers in making. Ma'am, I, on behalf of the entire team of Nyayshastram, thank you for being a part of this event and welcome you to this gathering. Over to you, ma'am.
Thank you so very much, Arif, for your very kind introduction. My warm regards and pranams to Khurshid sir, to my co-panelists, co-judges, Prakash sahab. I've not had the occasion to meet him, and our dynamic secretary of our Supreme Court Bar Association. I think he left all the leeway for me to question all the participants and took a little bit of a backseat. But I must start by congratulating each one of the participants in the final round that we got to interact with, and also all the participants who have participated in this moot court competition. I think it's irrespective of what the scores are, what we may have thought, and how marking we would have done. Let me tell you, you all were very well prepared. And let me tell you, the whole purpose of asking all the questions to you was not really to disarm you or to shake you up. It was only to exert a little pressure on you so that you get a feel of the court. After all, this is not a debate or an elocution. This is supposed to give you a feel of the court. And while you can sometimes find good judges like Prakash Saab and Ardhenduji, but sometimes you can find very very rude judges like me also. So I was just trying to be the devil's advocate here. And please understand that the whole purpose was to exert some pressure so that you get a feel of the real courtroom. You responded to questions very well. You did not allow my questioning to shake you, and congratulations and kudos to all of you. And my congratulations to the team of Nyayshastram. I have participated in your programs before. You have all been doing an incredible job. And I think the job that you're doing in current times when, there's so much of suffering all around, we have all struggled. There has been suffering in every house in the country today. In this time, if you are able to keep up positive activities involving students of law, my congratulations and salute to you really for continuing to do this with all the energy. I know how much effort it takes to do this. Please keep up the good work, because all of us need to be part of the solution in whatever small way or big way or one step or two step that we can. We have enough problems in the world, but in our country also, but if we can become part of the solution in some small way, that is a very positive attribute. So good luck to you, Godspeed, great strength, and God bless you all. Thank you so very much for having me.
Thank you, ma'am, for your kind words. Now invite Manvi, formally introduce Salman sir, and invite him to say a few words.
Thank you, Deepak. Good evening, everyone. I am Manvi, and it is my absolute privilege to be introducing our guest of honor, Mr. Salman Khurshid. Sir is a former Union Minister, designated senior advocate, eminent author, and a law teacher. A renowned legal thinker and a practicing senior advocate at the Supreme Court of India, he is known for his varied interests in different fields. He leaves a monumental impression in every field of endeavor he engages in and always looks for new vistas of action. Even as an educationist, his caliber is unparalleled. As very rightly worded in an article I came across, if sophistication and charisma, wit and sobriety, style and speech, vision and mission, work and art, all these can blend into one, the product would be Mr. Salman Khurshid. Sir, with this, I most humbly welcome you to the valedictory ceremony of Nyayshastram's second National Moot Court Competition. We are all beyond thrilled that you kindly accepted our invitation to be a part of this event, and we thank you again for taking out the time to be here.
Thank you very much indeed. It's such a delightful honor to be here with our wonderful colleagues from the bar. Aishwarya Bhati is right there, right in front, absolute tops, and you know, we just regret that physical courts not being open, we don't bump into each other, etc. that much. So thank you doubly for getting us together in this virtual space. Judge Prakash ji, we haven't come across, I believe, but it's so good of you to have found time to continue judging, as it were, beyond your call of duty, to continue judging. And I'm sure these young people will be delighted and absolutely honored that you have been able to look at their performance. Our young honorary secretary of the bar, Ardhendumauli Kumar Prasad, from a very distinguished heritage in law. I had the privilege to both appear before his father and to have known his father as a friend. And therefore, it's so wonderful to see the next generation here. And I do believe that you are really, really lucky to have them all. Now, I understand you've all worked laboriously over the last hour or so, listening to these remarkable judgment, the pronouncements and the analysis that's been provided. I was told that I should take 10 minutes to speak a little bit on the topic, and I found the topic difficult. The topic of conversion, topic of marriages. I mean, these are two such sensitive, such difficult, such complicated issues on which the law doesn't really, frankly, know what to do, because the problems continue to grow, continue to come back. Of course, we have formulations which would have been referred to and which have been amplified in this session today. But let me just say that since constitutional law is the backdrop of these two dimensions or aspects of the law, let me just say that as far as constitutional law is concerned, there is a fascinating dimension that recently the Supreme Court has been amplifying, particularly since the time of Chief Justice Deepak Mishra. I am absolutely not clear that the articulation has reached its end point, that it's been taken to a logical conclusion, but they have spoken of something called the constitutional morality. I've always believed that constitutional morality was an unnecessary articulation if the values of the Constitution were enough to sum up what we understand from the Constitution. But there is, going back many decades, there is a mention of constitutional morality in judgments of the court. There's been a mention of constitutional morality in the speeches before the Constituent Assembly, particularly of none other than Mr. Ambedkar. And therefore, constitutional morality seems to mean something special and something important. And I'm very happy to engage with this topic and to see what might happen in subsequent judgments. of what is constitutional morality. Is it something special? Now, certainly constitutional morality is not morality as we know it, of the everyday life and social morality or popular morality that we might speak of. Constitutional morality is something different. It's almost like the deep essence of our constitution. And the deep essence of our constitution can be dissected into several streams. And we know that the streams are reflected in Articles 14, 15, 16, in Article 19, Article 21, but it obviously goes much further. So it's the deep heart of the Constitution, I believe, with constitutional morality. But then how do you relate constitutional morality with the basic structure of the Constitution? This is something that scholarly lawyers and scholarly judges in time to come will have to amplify and clarify, and then, of course, amplify by way of judgments. But when we look at constitutional morality, it seems to me that many of the difficulties that we naturally encounter with conversion and marriage begins to get sorted out. It begins to get sorted out because I imagine the constitutional morality will one day give us answers to things like what is religion? I mean, we assume what is religion. There are very, very important writings on religion coming from different sources. But we have not yet examined, in the Indian context, of a religion without God. And that's a very major thought that's available now in jurisprudence, at least in the United States, in the work of Ronald Dworkin, religion without God. So you can have a religion, but you don't necessarily believe in God. How do we tackle that in constitutional morality? And then the whole concept of marriage is today under scrutiny. What is marriage? And you know, of all people, Malala, the great icon of freedom and education in the world, having survived terrorist attacks, etc., and having found a voice in the world, Malala is coming from a very traditional background in the northwest frontier of Pakistan, is coming out with a statement saying, if we like each other, why don't we just be able to live together? What is the purpose of marriage? And therefore, it's quite possible that marriage has lost the meaning that it was given in the times of the past. But if that were so as well, then the relationship that's described as marriage and sanctified by the state or by agencies of the state might well require and get an overhaul, complete overhaul. It's already getting an overhaul because marriage between sexes is what was understood of marriage. Now, marriage between same sexes is now continuing to knock on the door of the judicial process. Therefore, I believe that there is something really important that the very thought of constitutional morality will help us with in redefining many things that we have taken for granted, or many things that we have been subservient to, or we have been captive of, that we will be able to come out of that conceptual confinement and look at something larger, greater, more exciting, and something that will address the way we live in times to come. And when I say way we live in times to come, we are already under pressure to re-examine life because of the death and near-death experiences that we've had during COVID. We are already re-examining life. We will be redefining life, reworking life, readjusting life after the COVID finally settles down. And I assume that if that's going to happen, and then in the manner in which I've tried to touch upon certain issues in constitutional morality, we will be re-examining the constitutional life in many ways, and therefore ultimately life itself, which will give you very, very rich opportunity in your organization to continue to debate and continue to argue issues to a complete conclusion and get pronouncement long before the Supreme Court and the High Court start giving appropriate pronouncements on those. So in a sense, you would become, child is father of man, that the young lawyers here will become will show some patriarchy towards the judiciary to come, the judiciary of tomorrow. And who knows, you would be able to say that we redefined the constitutional dimensions of life, and indeed, ultimately, dimensions of life themselves. Thank you very much. I'm very happy to be associated with you.
Thank you so much, sir, for your insightful address. Kevin?
Thank you, Deepak. Good evening, ladies and gentlemen. Today, I have the honor of introducing one of our guests of honor, Mr. Ardhendumauli Kumar Prasad. Mr. Prasad is a second-generation lawyer and is an advocate on record practicing primarily before the Honorable Supreme Court of India. And he is also the Honorary Secretary of the prestigious Supreme Court Bar Association. In addition to this, sir is the Standing Counsel for the State of Uttar Pradesh and the Bar Council of India before the Honorable Supreme Court, and is also a senior central government standing counsel before the Honorable National Green Tribunal. Sir, we are indeed honored to have such an eminent personality such as yourself with us today, and I thank you for gracing us with your presence and taking time out of your busy schedule to be here with us today. Thank you.
But respected Salman Sahab, Aishwarya ji, when you have Om Prakash sir, Salman Sahab is there, Aishwarya ji is there, please don't address me as an eminent personality. The best part today was to hear Salman sir, and I do not know how much you guys learned, but we learned a lot when he was speaking. And what Aishwarya ji said was that I'm sure she was not rude. She was just trying to be tough to you guys so that you once you are there, you can understand the so-called tough judges and how to deal with them. I'm very thankful to all of you to have invited me, and it has been indeed a pleasure. And I'm very thankful to Salman Sahab to grace the occasion. I know he's very busy with the COVID situation and how much he's doing for the members of the bar, especially for Imtiaz Bhai, what he has done and what he did was we can't say anything more about it. So thank you so very much, sir, and thank you, Nyayshastram, for inviting me, sir.
Thank you, sir. Komal, please introduce Om Prakash, sir, and invite him to say a few words.
Good evening, everyone. It gives me great pleasure to introduce our guest of honor, Mr. Om Prakash. Sir enrolled as an advocate from the Uttar Pradesh Bar Council, Allahabad, in 1977. He joined the Bihar Judicial Services in 1984 as a Munsif and later became an additional district judge. Sir was promoted as a district judge in 2009 and retired from the post in 2016. Presently, Sir holds the position of State Information Commissioner, Patna. Thank you, sir, for gracing us with your presence.
It gives me privilege and honor to be a part of this moot court competition and to share the dais along with such legal luminaries, Salman Sahab and Aishwarya ji, as well as Ardhendu ji. I am thankful to the organizers of this moot court competition. I confess that I have experience of trial court, district court, and the queries made by Aishwarya ji has made me acquainted with the atmosphere of Supreme Court, how the judges ask questions about legal points. The subject matter of moot court discussed today is quite sensitive and debatable, particularly when different states have enacted laws regulating change of religion and marriage. The strength of our country lies in its acceptance of the plurality and diversity of our culture. Followers of different religions came to our country and they were adopted and they also became part of our culture, our civilization. Different faiths and religions have its own origin in this country, and with all these persons with different faiths and culture, they are living here calmly, peacefully. Certainly, the residents of this country adopted these new faiths and religions, and our culture accepted it. The principle of unity in diversity, coexistence, and respect to other religions was adopted in our constitution, has been adopted in our constitution also. Article 25, 26, 27, and 28 of Indian Constitution deals with the right to freedom of religion, which has been incorporated in the chapter of fundamental rights. Article 21 guarantees life and personal liberty to every individual. Now, to my mind, religion and marriage are two different concepts with different objectives. Although marriages are mostly governed by the norms and religion to which the parties belong. However, a Special Marriage Act has given legal sanction and procedure for the marriage of two individuals, irrespective of their religion or caste. A party to a marriage has a right to continue with her or his pre-marriage religion or faith. Thus, religion is no more an essential requirement of solemnization of marriage. Marriage may be solemnized between persons of different religions and faith, even without changing their faith or religion. Objective of marriage is normally procreation and creating lineage to one's family. Marriage is a matter of choice of two individuals. Religion, on the other hand, is a matter of faith of each and every individual. The courts of India have been insisting on these principles of individual decisions in the matters of marriages by saying that it is facet of Article 21 of our Constitution. The problem arises when the delicate balance between choice of a marital partner and choice of faith is disturbed. When one of it is made condition precedent for the other, when the person is asked or persuaded to sacrifice his religion or marriage to continue with the other, both rights are protected under Article 21 of our Constitution, and when the delicate balancing between the two are disturbed, the problem arises and courts have to interfere. Thus, we hope the judgments of the courts have maintained the delicate balancing between the religion and the marriage. And with these words, I conclude my address. I am thankful to the organizers of this moot court competition. Thanks again.
Thank you so much, sir. Aniket, over to you for the prize.
Thank you, Deepak. Quickly moving on, with all the judges' permission, we have now come to the most awaited segment of the valedictory ceremony of Nyayshastram Second National Moot Court Competition 2021 on the theme of Constitution, Religion and Marriage, with PSL, PS Legal, advocates and consultants as exclusive empowering guides, and Fiducia Legal advocates and solicitors as our associate partners. We are going to now announce the results in the categories as Best and Second Best Speaker, Memorial and Researcher, then third runner-up, second runner-up, then winners, and lastly the first runners-up, for which I shall be asking the dignitaries to read out the names one by one. So for the first category, that is the second best and the best memorial, I request Praveen sir to read from the poster as I share.
Hi. The second best and best memorial is second best is Aishwarya V, Mansi Jain, and Megha Mahesh of School of Excellence in Law, Chennai. And the best is Maria Bini, Sindhu G, Kaushik, Neha Susan Thomas of Christ University, Bangalore. Congratulations.
If the teams are present, they may switch on the cameras. Sorry.
That's fine.
So, moving on, I request Mr. Om Prakash sir to declare the results in the category of second best and best researcher. So you may read from the poster itself.
The second best researcher is Molika Agrawal, representing over Government Law College, Mumbai.
Moving on.
Dhaval Bothra, representing Symbiosis Law School, Pune, is best researcher.
The best researcher bags a cash prize of rupees 2100 and a free publication opportunity at Burnished Law Journal. Moving on, I request Om Prakash sir to continue with the second best speaker.
The second best speaker is Sven Thapal Oman, representing School of Law, Christ University, Bangalore.
Moving on to the best speaker.
Best speaker is Mansi Sethias Jain, representing School of Excellence in Law, Chennai.
Thank you, sir. The best speaker bags a cash prize of 2100. Moving on to the third runner-up, I request Praveen Nagar sir to declare the name of the third runner-up team.
I'm not sure who's the third runner. So Divyanshu Ganesh, Apurva Srivastav, and Karan Bharti. They're representing the Rajiv Gandhi National University of Law, Punjab. Congratulations.
Thank you, sir. So the second runners-up of the competition are V. Kirtana, M. Rameshri, and R.K. Padmanabhan, representing School of Excellence in Law, Chennai. And we have now come to the most awaited segment of the competition, that is declaration of the names of the winner. And before I ask Salman sir to read out the names, I'd like to inform everyone that it was a tie with respect to the oral scores of the teams. And as organizers, we are bound to follow the rules, which states that the memorial scores will decide the tiebreaker. So we'll now moving on to the next poster, which shows the names of the winning team. I request Salman Khurshid sir to read out the name.
So that's the top of the day winners, Ariana, Diljitovna, and Mahek and Mahek Upadhyay, and they both represent the Amity Law School, Noida, which is wonderful for both of them. Congratulations.
Thank you, sir. Congratulations, winning team. The winning team bags a cash prize of 11,000 rupees and an internship opportunity at PS Legal. Moving on to the next category, I request Aishwarya Bhati ma'am to read out this name. Okay, I'll read it out for you, needless to say. So let's hear it for the team that gave the toughest competition to the winning team. The team comprises of Vineeth, Prasad, Sylvinn, Simjo, and Maria Villara, representing School of Law, Christ University, Bangalore. The team bags a cash prize of rupees 5,100 and an internship opportunity at Fiducia Legal. Congratulations to all the winners. I now invite Mr. Abhishek Bhushan Singh to render the vote of thanks. Over to you, Abhishek.
Thank you, Aniket. I hope I am audible. I, Abhishek Bhushan Singh, Managing Director, Nyayshastram, take great pride and privilege to have been given this opportunity to propose the vote of thanks. On behalf of the entire team of Nyayshastram, I would like to express our heartfelt gratitude towards all the guests who have graced us with their presence and provided very valuable insights while addressing the gathering today. I'm sure your words have definitely encouraged students to take up more mooting activities in the future. First and foremost, I express my sincere gratitude to the chief guest, Sri Salman Khurshid sir, for having partaken in the valedictory ceremony of the second National Moot Court Competition 2021, despite his demanding schedule. The participants have benefited immensely from the inputs provided by you, sir. We thank you for gracing this event. I am immensely grateful to the guest of honor, Aishwarya Bhati ma'am, For being part of the event, I am certain that participants have had a lot of lucrative and fruitful knowledge to gain from you. Your presence amidst this gathering today is deeply valued by us now. I am immensely grateful to the guest of honor, Sri Om Prakash sir, for being part of our event. I am certain that the participants have had a lot of lucrative and fruitful knowledge to gain from you. Your presence amidst this gathering today is deeply valued by us, sir. I am immensely grateful to the guest of honor, Sri Ardhendumauli Prasad sir, for being part of this event. The participants have benefited immensely from the inputs provided by you, sir. We thank you for gracing this event. At this juncture, I take this opportunity to thank our Chairman Advisory Board, Sri Ratan Kumar Singh, Senior Advocate, and all the members of Advisory Board for their unending support and guidance. I would like to acknowledge our exclusive empowering guide, PSL, PS Legal Advocates and Consultants, for rendering their support and having confidence in our team by allowing us to collaborate with them for this event. I would also like to thank our associate partner, Fiducia Legal Advocates and Solicitors, for their support. The constructive feedback given by Praveen Nagar sir and Animesh Kumar sir have been giving us all throughout has helped us in achieving our vision to organize it so well. Furthermore, I would like to thank our support partners, Memo Pandits, Lex Mekula, and Burnage Law Journal. I would like to acknowledge Ms. Divya Kedia ma'am for drafting the problem for the competition. As Henry Ford said, once said, coming together is a beginning, keeping together is progress, and working together is a success. I would like to thank my co-founders, Aniket Datta and Deepak Thakur, who has been a constant support, without whom this event would not have been conducted the way it was. On behalf of my co-founders and I, this event has been our long-lasting vision for the Nyayshastram, and we are humbled to see it turn into fruition. This vote of thanks would not be complete unless I thank the entire team of Nyayshastram. I must admit, on behalf of my co-founders as well, that we have a dedicated group of team members who have always worked as a team and have been our pillars of strength throughout this event. Thank you.